Good morning. Welcome to the 294th District Court. My name is Chris Martin. I'm going to call this morning's criminal docket. When you hear your name, please say present or here. Kyle Holland. Here. Mark Martinez is appearing via Zoom today with court's permission. I believe that Mr. Martinez is present in the Zoom waiting room. Vincent Alford. Vincent Alford. James Arnold, CR 25-117. Court's received information that Mr. Arnold is in a rehab center in Rockwall with an autoimmune disorder. We'll recall that case, Mr. Manning. Charles Brown. Laquandre Colon.
Judge, I spoke to my client this morning. He is out of state and he was running a little bit behind. He emailed me at 6:40. He is in the state of Texas, but he's still on his way.
All right, thank you, Mr. Manning. Stephen Martinson.
Here.
Derek Munns. Michael Patterson. Brandy Ross. Misty Tadlock. Clifton Thomas. Demetrius Windsor. James Burleson. Anthony Fernandez. Wilford Moore. Jimmy Pickens. Dustin Dupree. Michael Ringgold. All right, is there anyone in the courtroom your name's not been called? Your name, sir? Omar Galan. Ms. Tabraham, will you take Mr. Galan? Go with Ms. Tabraham here. Let her look up your case and let's make sure that you're here on the right date or see if I made a mistake and not putting you on. Anyone else in the courtroom your name's not been called? All right, we have any counsel that's ready? I'm ready. Who'd you like first, Mr. White?
Mr. Pickens.
Did you say Mr. Pickens?
Yes, sir.
Jimmy Don Pickens, CR 25-102. Mr. Pickens is set for pretrial today.
Your Honor, I'm still trying to get some information on this case from Smith County. I formed that state of that, asked the court for a reset on the pretrial.
Is the info from Smith County related to pretrial motions or is it just related to trial?
It could be, Your Honor. I need to check something.
Any objections from the state?
No, Your Honor, thank you.
All right, court will reset Mr. Pickens for pretrial. What day will you be here in August, Mr. White?
I believe we got August 16th and 14th. Is that correct?
We got 12th and 14th. I think it was the 14th. Is it Thursday? Is that right? All right, court sets Mr. Pickens for Thursday, August 14th for pretrial. Once he signs his notice, he's free to go. Who would you like next?
Mr. Burleson.
James Darrell Burleson, CR 25-92. Mr. Burleson's also set for pretrial.
Your Honor, we don't have any contested motions. We'll abide by the court's pretrial or standing pretrial order and ask the court to move this over to docket call.
All right, court sets Mr. Burleson then for docket call August 14th at 9 a.m. Once he signs his notice, he's free to go.
There they go to the office. Yeah. Just give us a couple of days. So we can Mr. Fernandez. Fernandez.
Anthony Paul Fernandez. Cause number CR 25-73, and Mr. Fernandez is set for docket call.
Your Honor, at this time, I was made aware of something during the course of our investigation that I need to look at. I'm going to need another docket call. I don't believe the state objects to that.
Mr. Hernandez.
No objection, Your Honor. Thank you.
All right, there being no objection, court sets Mr. Fernandez for docket call August 14th, 9 a.m. Yeah, pretty good. Who's next?
Mr. Moore.
Wilford Kenneth Moore, CR 25-82. Mr. Moore is set for pretrial.
Your Honor, we do not have any contested pretrial motions. Ask the court to move this over to docket call.
Court sets Mr. Moore for docket call August 14th, 9 a.m. Once he signs his notice, he's free to go. Mr. White.
Mr. Ringgold.
Michael Thomas Ringgold. Cause number CR 20-356. And I believe Mr. Ringgold is here on a motion to adjudicate.
That's correct, Your Honor. I believe the state will join me on this, but we're going to ask the court to move this over to the contested docket. I believe you have one on August 28th, if I'm correct. We can't get it worked out that day. We'll have to have it here.
Any objections from the state?
No, Your Honor. Thank you.
All right, court sets Mr. Ringgold for the contested docket August 28th at 9 a.m. Once he signs his notice, he's free to go.
And I do have a case on the 130 docket, but he's not here. He's in Dallas County. It's Mr. Mengistu. Take that up.
All right, for the record, cause number CR 24-143, State versus Obed Baru Mengistu. Court will reset Mr. Mengistu, finds that he is still incarcerated in Dallas County. And we will reset Mr. Mengistu. Do you have your calendar for October, Mr. White?
I do, Your Honor.
Look at October 14th or 16th.
Let's do the 16th, Your Honor.
Court sets Mr. Mengistu for status custody October 16th. And Mr. White, do you have any updates for the court on Mr. Mengistu's legal status in Dallas County?
No, sir, I don't. We were trying to get an update prior to court, and we were never able to get in touch with anybody that could give us one.
Does the state have any information on their prosecution in Dallas County?
Not to date, Your Honor. We will follow up. Thank you.
All right. Thank you, Mr. White. Good to see you.
Thank you.
Mr. Manning, you ready?
Yes, sir.
Sorry, Mr. Manning, go ahead.
Judge, ready on Mr. Arnold.
James Douglas Arnold, cause number CR 25-117. Court finding that Mr. Arnold is in a rehabilitation center in Rockwall will reset this case for arraignment. Is there any objections from the state?
No, Your Honor, thank you.
All right, court resets. Mr. Manning, do you have any additional information other than what the court already has on Mr.?
Judge, that was the first I've heard of Mr. Arnold's whereabouts.
We'll reset Mr. Arnold for arraignment September 18th. I'll have Ms. Taberham see if we get some more information from this rehabilitation center on what his status is and release.
Thank you, Judge.
Who else are ready on?
Judge, next ready on Mr. Martinson.
Stephen Martinson, cause number CR 25-50. Sir, you cannot take a phone call in the courtroom. And the only reason I know you're doing that, one, I can hear you, but two, your flashlight is on. So you're showing me, hey, I'm on my phone, I'm on my phone. So if you want to take a phone call, you need to step out of the courtroom. All right, this is Mr. Martinson. He's set for docket call in this case and also CR 25-51. Go ahead, Mr. Manning.
Yes, Judge, we'd like to announce ready for trial and request to be set on the jury selection docket.
All right, and what offer, if any, was made by the state that's been rejected by the defense?
Judge, I don't recall we ever made an offer. We may have been, but my client wasn't interested in taking any offers.
So your client rejects any and all offers, if any were made?
Yes, Judge, I've explained to him the process of the court, which includes that if there is a plea offer made and he rejects that, the court, even if it is reoffered in the future, court may not take that up, having it been denied and been set on the jury selection docket.
All right. Court will set Mr. Martinson on the trial docket beginning next week, August 4th. He'll need to report to the courthouse on the 4th at 8:30 a.m. and meet with my staff downstairs. If he's not in the top 10, then he'll be reset. He'll check in with a pretrial release officer. If he is in the top 10, he may be liable for trial.
Judge, I have received the top 10 list. I believe that top 10 list was already full at this time, but I will keep it, Mr.
If he's not in the top 10, then they'll reset him and they'll check in with pretrial release and be free to go.
Thank you, Judge. Judge, next ready on Mr. Munns.
Jarek Chase Munns, cause number CR 25-100. I'll show that Mr. Munns is set for pretrial today.
Yes, Judge. Mr. Munns was previously in custody. He was able to bond out, and I have not had an opportunity since then to go over his discovery with him. Additionally, Judge, we did receive a new offer or an offer on July 7th. I have not had an opportunity to convey that to Mr. Munns and discuss that. So we request additional pretrial on this matter.
Any objections from the state?
No objection, Your Honor. Thank you.
There being no objections, court recess Mr. Munns for pretrial August 14th at 9 a.m. But
Thank you, Judge. Miss Ross.
Brandy Nicole Ross. Cause number CR 25-39. Ms. Ross set for pretrial.
Yes, Judge. With Miss Ross, I have also received a new offer that I need to discuss with her, as well as go over some of the discovery and some potential pretrial issues, if I may have additional pretrial on her case.
Any objections from the state?
No objection, Your Honor.
All right, there being no objection, court recess Ms. Ross for pretrial August 14th. 9 a.m. Once she signs her notice, she's free to go.
Thank you, Judge. Judge, ready on Miss Hadlock.
Misty Amber Tadlock, cause numbers CR 25-110, 111, 112, 113, 114. All cases set for pretrial.
Yes, Judge. Ms. Tadlock and I have been in conversation about the discovery in her case. We've gone over most of that discovery. However, there is some documentation that she is working on providing, that I can provide for mitigation and possibly exculpatory information to the DA's office. I request additional pretrial issue for her to gather up those items. They were financial documents from a service that they no longer use, and so it's taken a little bit longer for her to get those archived documents for us to provide the DA's office.
Will those affect your pretrial motions?
Judge, they may be dispositive on some of the cases. And I don't know specifically which of those cases, which case numbers we would be ready to proceed on, and which case numbers we're still waiting on the information for.
But wouldn't affect any evidentiary hearings on a pretrial motion? Sounds like to me like it's a docket call issue, like you want to provide mitigation, and if it's disposed of, it can be disposed of docket call. But is there anything, a reason that we should not go forward to docket call because it's going to affect motions to quash, motions to suppress, production of discovery from the state?
Judge, my only concern is that if documentation that she provides me, which I anticipate is going to contradict the documentation that's provided by the state, if they get supplemental information, that may leave us in a bind, not knowing if there's more information out there. As I said, this is a financial crime with lots of moving parts, lots of different individuals. And so if there is a lack of documentation in several of the cases that may be supplemented, and we'd like to reserve our right to contest those if there's any necessary pretrials on those issues.
I think what I'm going to do is I'm going to set her for docket call, and then I'll grant you leave to file motion to any kind of pretrial motions that you need to late.
Thank you, Judge.
And how much time do you need to gather this information and get to the state? Is 30 days going to be enough?
Let me speak to my client. We spoke again on Monday or Tuesday. So let me see where she is in the process. Judge, she has put in a request for those documentations, but she's not gotten any response at this time, so I can't provide the court any idea. If we could have 45-day maybe, that should give us time to.
Any objections from the state?
No objection, Your Honor.
I'll give you a little bit more than that. Mr. Main, I'll give you September 18th.
Thank you, Judge.
Court setting Ms. Tadlock for docket call September 18th in all cases. Ms. Tadlock, make sure you meet with the pretrial release officer today. If you're not coming back to court next month, they may want to have you check in. So make sure that you check in with them today to find out when your next report date is.
Thank you. Judge, at this time, I believe all the remaining cases I have are gonna be pleas. So if I may have some time just to get those
Yes, sir.
set up.
Mr. Gallant. This is cause number CR 22-20, State of Texas versus Omar Eloy Galan. Mr. Galan, I'm sorry I didn't have you on the docket today. I think you were a late addition. You're here for a request to extend your probationary period. Is that right?
Yes, Your Honor.
Looks like you're asking the court to extend your probationary period an additional 12 months. Why do you need more time on probation?
Just to get my fees paid off, sir.
And you understand if the court extends your probation, you're going to have additional probation fees and your analysis fees during that period.
Yes, sir.
And it looks like it's going to be reduced to $20 a month for probation and $5 for your analysis. If I extend your period of probation, do you believe that you will be more likely to successfully complete?
Yes, Your Honor.
All right. And Mr. Galan, has anybody threatened, forced, or pressured you to enter into this or ask the court to extend your probationary period?
No, sir.
All right, court will extend Mr. Galan's period of probation an additional 12 months with a new expiration date of August 8th, 2026. Court will also amend the conditions regarding probation fees and your analysis fees. Mr. Galan, come over here and see the probation officers. You're free to go.
Yes, sir. Thank you.
All right, good morning, Mr. Martinez. Can you see and hear me okay?
Yes, sir. Good morning. First and foremost, thank you for letting me do it like this, sir.
Yes, sir. Court's going to call your case. This is cause number CR 25-97, CR 25-122, State of Texas versus Mark Anthony Martinez. Mr. Martinez set for arraignment today and status on hiring an attorney. Court finds that Mr. Martinez appeared in the court offices yesterday requesting an extension for additional time to retain an attorney. Mr. Martinez, it's my understanding that you're asking the court to reset your case until August 26th to give you time to hire an attorney. Is that correct?
Yes, and also I told her about September, sir. It's that me being I already passed the canopy business to my mother, but I'll still be running it, and my truck, I gave it up. So like all the bills, I'm not in charge of the money no more. So all the money goes to her now, but I'm still gonna run the business for her. But our biggest show is in September. That's when we make good amount of money. But I've been doing side jobs and everything. I've called 3 lawyers, and some lawyers, they won't accept the case. Some lawyers, they want a lot of money. And so I asked her if she could have leniency with me, and as I look for a lawyer, because I don't think a court-appointed lawyer is good for me right now.
Well, Mr. Martinez, I'm going to reset you to August 26th, and that's the day I'm going to expect you to have hired an attorney, because I'm giving you an additional almost 45 days in addition to the 30 days I already gave you. So
Right, sir.
we're not going to go past August 26th. So you need
Okay.
to have that business taken care of. So whatever you need to do on your end, you need to get it done. It needs to be priority one. All right, so I'm gonna order you back before the court in person on August 26th at 9 a.m. Okay?
All right.
All right,
Thank
you're
you,
free to,
sir.
you're welcome. You're free to go.
How do I get out of this?
Don't worry about it. I'll kick
Oh.
you out.
All right. Thank you.
You bet.
Bye.
Have a good day.
You too. Bye.
You hurt? Sounds like he's hurt. Mr. Dupree?
Good morning, Judge.
Good morning, Mr. Weiner. You see and hear me okay?
Yes, sir.
All right, court calls State of Texas versus Dustin Dupree, cause numbers CR 23-210, 211, 212. What's the announcement from the defense, Mr. Weiner?
Your Honor, I've been working with the state towards a resolution on this case. We are the #1 case set for jury trial next month. We've been working very hard to get a resolution. We finally came to a resolution yesterday afternoon. As soon as we came up with that agreement, we contacted your court staff, let them know, and we were told to go ahead and file a waiver of jury trial. I signed that and emailed it to the state. I believe they have it there for my client to sign so he can be admonished and we can set this case for a plea.
State.
Your Honor, that is correct. I've actually also added in case numbers 211 and 212, and I wanted the counsel to be aware of that to the signed waiver of jury trial.
Make sure your microphone's on.
My apologies. We did receive the executed waiver of jury trial signed by counsel, Your Honor. I've added the case numbers 211 and 212 at the top under cause numbers. I've signed it. If I may approach the bench, or shall I approach Mr. Dupree to have him sign it first?
Let Mr. Dupree see it, sign it. Have you already counseled your client on the waiver of jury trial, Mr. Weiner?
I've admonished him, Judge, yes.
Okay.
Sorry, I don't think my reception's awesome in the county court room in Cherokee County.
It's okay. It's actually coming through pretty good.
If I may approach the bench.
Yes, yes. And let me go ahead and ask counsel, why is this case being resolved now by recommendation of plea when it wasn't a year ago?
Your Honor, we've actually spoken with the alleged victim in this matter who's now moved out of the area. There was some logistical concerns, although they were very willing, both the mother and the alleged victim, to come before the court and testify. We thought under the circumstances, this was the appropriate plea. We consulted with the family. They are in agreement, and that's why we're taking this path.
Okay. All right, Mr. Dupree, if you'll raise your right hand, I'm gonna place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you can lower your hand. All right, Mr. Dupree, in each one of these cases, you are represented by your attorney, Mr. Justin Weiner, correct?
Sure.
And you've talked with Mr. Weiner about your case regarding your rights. You've also talked to him about, I'm sure, your trial preparation and preparing for trial next month. Is that correct?
Yes, sir.
And Mr. Weiner, you heard him announce today that he and the state with you have reached an agreement on how to dispose of your cases by plea agreement. Is that correct?
Yes, sir.
Part of that requires you to waive your right to a jury trial. And waiving your right to a jury trial is something that you and only you can do. Mr. Weiner can't waive it. The state can't waive it. I can't waive it. You understand that?
Yes, sir.
It's a right that's afforded to you and you alone. And it's an important right because your right to a jury trial guarantees that you have the right to confront the state's witnesses, cross-examine them, and all of the evidence from witnesses and any other evidence. You understand that?
Yes, sir.
You understand that once you give up your right to a jury trial, that right may not be restored to you.
Yes, sir.
And it's indicated to me that you are wishing to waive your right to a jury trial in each one of these cases so that you can resolve your cases by plea agreement with the state. Is that right?
Yes, sir.
Mr. Dupree, has anybody threatened you, forced you, or pressured you to waive your right to a jury trial here today?
No, sir.
Mr. Weiner, do you join in with your client, Mr. Dupree, on waiving his right to a jury trial?
Yes, Your Honor, I do.
And I see the state is also waiving its right to a jury trial, Mr. Hernandez.
Yes, Your Honor. Thank you.
All right, the court finding that Mr. Dupree, having been admonished and with the assistance of counsel, has intentionally, knowingly, and voluntarily waived his right to a jury trial in cause numbers CR 23-210, 211, and 212. The court is going to approve the waiver of jury trial and set this matter for plea. And is there any plea logistics that we need to work around, or do we have allocution? Do we have victim schedules?
We may, Your Honor. However, I think if we were to get maybe a week or two, I believe Mr. Weiner's out of town next week anyway. So if the court would like to set it the following week, the state would not be objecting to that. If Mr. Weiner is amenable.
I'm fine with that, Judge, and that's kind of the reason we're doing this kind of the last second today, because I'm heading out of town tomorrow. We appreciate you accommodating us.
Look at your calendar. I think the next available for the court would be the 12th or the 14th. I'm not sure. You may be here already on one of those days, but I'm not certain.
Yes, Your Honor, I'm actually there on the 14th. That would be fantastic.
All right, court says Mr. Dupree then for plea August 14th. Is that a morning plea or afternoon plea?
A morning plea, Your Honor.
All right, at August 14th at 9 a.m. All right, I'm going to have your client sign a notice of appearance, Mr. Weiner, and then he's going to be on his way.
Thank you so much. May I be excused?
Yes, thank you, Mr. Weiner. Good to see you.
Appreciate you.
You're welcome. Mr. Holland. All right, this is a sanctions court hearing, cause number CR 20-291, State versus Kyle James Holland. All right, let's see, Mr. Holland. Looks like from our last sanctions court, you were ordered to pay your probation fees. You did that. You ordered to complete your community service. You did that. It says that you failed to comply on your $120 to court collections. Have you paid that
Yes, sir. I paid that a couple of days ago.
a couple of days ago? Do you have your receipt for that?
I believe I have an electronic receipt in my email.
Do you have your phone with you?
Yes, sir.
All right, I'm gonna reset you. I want you to show that to the probation officers before you leave. And I'm going to set you August 14th. You're ordered to pay $60 to probation, $170 to your court collections. So those two things, Mr. Holland, okay?
Yes, sir.
Yeah, he's worked his hours. You completed all your community service, I see.
I believe so.
It's good. right, court's going to stand in recess until Mr. Manning is ready on his cases. So we're in recess. It's 9:42. We'll be in recess for at least 20 minutes, at least 20 minutes. So you're free to move about and enter next to the courtroom. I'm going to see it just a second, Joe. All right, Mr. Manning, who are you ready on?
If we can start with Mr. Cologne. McQuandre Cologne.
Mr. Cologne, cause number CR 25-70 and 71, State versus Laquandre Daquan Cologne. All right. Plea today.
Yes, Judge.
Do you pronounce your last name Cologne?
Colon.
Colon, okay, I'm sorry. All right, Mr. Colon, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right, thank you. You can lower your hand. Mr. Colon, you are represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning and the work that he's done for you as your attorney?
Yes, sir, Your Honor.
Are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
Do you understand everything that you've read and signed today?
Yes, sir.
Do you have any questions for Mr. Manning or the court before we go further?
No, sir.
Mr. Manning, do you believe your client to be competent? And if so, have you explained to him his rights regarding the case?
He is competent. I have explained his rights, and I believe he's waiving those rights intentionally, knowingly, and voluntarily.
Have you also discussed with him the advantages and disadvantages of a deferred adjudication plea?
I have, Judge.
Mr. Colon, you are charged by indictment with a third-degree felony offense of possession of a controlled substance in penalty group 4 between 28 grams but less than 200 grams. A third-degree felony does carry a range of punishment of not less than 2 years in prison and up to a maximum of 10 years in prison and a possible fine not to exceed $10,000. I see that the plea agreement in your case, upon you pleading guilty to that crime, the state's recommending that the court consider the evidence, not convict you, but rather place you on deferred community supervision for a period of 4 years. As part of that community supervision recommendation, you would also be responsible in order to pay a $1,500 fine, $290 court cost, $535 reimbursement fees for your legal costs, and also 100, I think I already said $180 restitution. And the state would also be asking the court to dismiss your other case, which is CR 25-70, which is also another possession of controlled substance, a state jail felony. Mr. Colon, is that your understanding of the plea agreement?
Yes, sir, Your Honor.
All right, understanding the range of punishment, understanding the plea agreement, Mr. Colon, how do you plead to possession of a controlled substance in penalty group 4, greater than 28 grams, less than 200 grams, a third-degree felony?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
Has anyone threatened or forced you or pressured you to plead guilty to this crime today?
No, sir, Your Honor.
All right, the court does accept the defendant's plea of guilt. Mr. Manning, any objection to the stipulation of evidence?
No objection as offered.
All right, the stipulation is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
From the defense?
Rest in close, Judge.
The court will review the evidence. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant of the offense. The court will follow the plea agreement. Court hereby defers a finding of guilt. Places Mr. Colon on 4 years community supervision, orders him to pay a $1,500 fine, $180 restitution, $290 court cost, and $535 in reimbursement fees. And the court dismisses under section 1245, cause number CR 25-70, possession of a controlled substance in penalty group 2. Mr. Colon, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm gonna have you come forward to be fingerprinted with the bailiff.
Yes, sir.
After that, you'll meet with the probation officers. Mr. Manning, who's next?
Judge, we can go with Mr. Patterson.
Michael Scott Patterson, CR 23-15. All right, Mr. Patterson, if you'll raise your right hand, I'm going to place you on oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you can lower your hand. Your name is Michael Scott Patterson.
Yes, sir.
Mr. Patterson, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning as your attorney and the work that he's done?
Yes, sir.
You understand everything that you've read and signed today that's part of your plea agreement?
Yes, sir.
Do you have any questions about anything before we proceed?
No, sir.
All right, Mr. Patterson, you have been charged by indictment with a third-degree felony offense of possession of a controlled substance, felony group 1 or 1B, greater than 1 grams and less than 4 grams. That does carry a range of punishment of not less than 2 years in prison, up to a maximum 10 years in prison, and a possible fine not to exceed $10,000. I see the plea agreement in your case. Upon you pleading guilty, the state's recommending to the court that the court consider the evidence, convict you of the offense, assess your punishment at 3 years confinement in prison, along with a $1,500 fine, restitution of $180, court cost of $290, and reimbursement fees of $85. Mr. Patterson, is that your understanding of the plea agreement?
Yes, sir.
And Mr. Manning, what credit time would Mr. Patterson be entitled to?
Judge, the agreed credit time confirmed by my client was 395 days.
395?
That's correct.
And Mr. Patterson, you would receive upon accepting this plea, 395 days credit towards your sentence for the time that you've already spent in jail. All right, Mr. Manning, do you believe your client to be competent today?
I do, Judge.
And you've explained to him his rights regarding this case?
Yes, Judge. We've extensively gone over both his rights and the discovery in this case. And I believe he is entering into this potentially knowingly and voluntarily.
All right, thank you. All right, so Mr. Patterson, as to that charge, how do you plead?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
And has anyone threatened you, forced you, or pressured you to plead guilty?
No, sir.
Court does accept the defendant's plea of guilt at this time. Mr. Manning, any objection to the stipulation of evidence?
No objection as offered.
Stipulation is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
Rest and close, Judge.
All right, court will review the evidence. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant of the offense. The court follows the plea agreement and recommendation from the DA's office. The court hereby convicts Michael Scott Patterson Jr. of possession of a controlled substance of felony group 1, greater than 1 grams, less than 4 grams. Assesses punishment at 3 years confinement in the Texas Department of Criminal Justice, orders him to pay a $1,500 fine, court cost of $290, restitution of $180, and reimbursement fees of $85. Further, the court does award Mr. Patterson 395 days credit towards this sentence for the time that he has spent in jail on this cause. Mr. Patterson, you hereby remanded to the custody of the sheriff's office so they can carry out the terms and conditions of the sentence. I'm going to have you come forward to be fingerprinted, and then you'll be taken into custody. Who's next, Mr. Manning?
Judge Rio, Mr. Clifton Thomas.
Clifton Glenn Thomas, CR 25-86. Mr. Thomas, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right, you can lower again. Your name is Clifton Glenn Thomas, is that correct?
Yes, sir.
And Mr. Thomas, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning and the work that he's done as your attorney?
Yes, sir.
Do you have any questions about your case for Mr. Manning or the court before you proceed? Mr. Manning, do you believe Mr. Thomas to be competent? Have you explained to him his rights regarding the case, including the advantages and disadvantages of a deferred adjudication plea?
Judge, I do believe he understands his rights and is waiving this intentionally, knowingly, and voluntarily. I have explained to him the consequences, both positive and negative, of taking deferred probation, and he understands those.
Mr. Thomas, you are charged by indictment with a second-degree felony offense of burglary of a habitation. A second-degree felony does carry a range of punishment of not less than 2 years, up to a maximum of 20 years in prison, and a fine not to exceed $10,000 if imposed. I see that the plea agreement in your case, upon you pleading guilty to that crime, the state's recommending that the court consider the evidence, not convict you, but rather placing you on deferred adjudication for a period of 8 years, along with a $2,000 fine, 151 days confinement in the county jail as a condition of your community supervision, for which you will receive credit for time that you've already spent there. In addition, the state is agreeing to ask the court to dispose of an unfiled resisting arrest. And as part of the agreement, you would be ordered not to go within 200 feet of the victim or the victim's address during the term of your community supervision. Is that your understanding of the plea agreement?
Yes, sir.
All right, Mr. Thomas, understanding the plea agreement and the range of punishment, how do you plead to burglary of a habitation?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes.
And has anyone threatened you, forced you, or pressured you to plead guilty?
No, sir.
All right, the court will accept the defendant's plea of guilt at this time. Mr. Manning, any objection to the stipulation of evidence?
No objection as offered.
Stipulation is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, thank you.
Anything further from the defense?
Rest and closed, Judge.
All right, court will review the evidence. All right, the court having reviewed the evidence, finds enough evidence to convict the defendant of the offense. The state follows the plea agreement between the defendant and the state. Court hereby defers a finding of guilt on the second-degree felony burglary of a habitation. The court places Mr. Thomas on 8 years community supervision, orders him to pay a $2,000 fine, $290 in court costs, $540 in reimbursement fees. Court orders him to serve 151 days in the county jail as a condition of his community supervision. The court will give Mr. Thomas credit towards that condition for the time served between January 13th, 2025 through June 12th, 2025. Further, the defendant is ordered not to go within 200 feet of the victim or the victim's address during the term of community supervision. Mr. Thomas, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm going to have you come forward to be fingerprinted with the bailiff. After that, you'll meet with the probation officers.
Sir.
All right, who's next, Mr. Manning?
Judge, next we have Mr. Charles Brown.
Charles Timothy Brown. Cause numbers CR 25-64 and 65. Mr. Brown, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thank you. Your name is Charles Timothy Brown, correct?
Yes, sir.
And Mr. Brown, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning and the work that he's done as your attorney?
Yes, sir.
You understand everything that you've read and signed as part of your plea agreement?
Yes, sir.
All right, Mr. Brown, you've been charged with a state jail felony offense, burglary of a building that does carry a range of punishment of not less than 6 months in prison up to a maximum 2 years in prison, that being a state jail prison, and a possible fine not to exceed $10,000. I see that there is a plea agreement in your case wherein upon you pleading guilty to that charge, the state's recommended to the court that the court consider the evidence, not convict you, place you on deferred community supervision for a period of 3 years, along with a $2,000 fine, plus court costs of $290 and reimbursement fees of $535. It appears that the state is recommending that the court dismiss your other indicted costs, CR 2565, which is an engaging in organized criminal activity, be dismissed pursuant to section 1245 of the Texas Penal Code. Is that your understanding of the plea agreement?
Yes, sir.
Mr. Manning, do you believe Mr. Brown to be competent to enter into this plea agreement today?
Do Judge?
And you've explained to him his rights regarding the case and the advantages and disadvantages of a deferred adjudication plea?
I have.
All right, Mr. Brown, at this time, how do you plead to burglary of a building?
Yes.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
Court does accept the defendant's plea of guilt at this time. Mr. Manning, any objection to the stipulation of evidence?
No objection as offered.
Stipulation is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, thank you.
From the defense?
Rest on close, Judge.
All right, court will review the evidence. Mr. Hernandez, was there any claim for any restitution by the victim of this offense?
Your Honor, the property was recovered in Kaufman, both the currency and the box of cigarettes allegedly taken.
What about the broken glass on the front doors to the business?
We never received any additional information on that, Your Honor.
All right, the court, having considered the evidence, will follow the plea agreement or hereby defers a finding of guilt on the offense of burglary of a building. Court places Mr. Brown on 3 years community supervision, orders him to pay a $2,000 fine, $290 in court costs, $535 in reimbursement fees. Court does dismiss under section 1245, cause number CR 2565. Mr. Brown, you hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm gonna have you come forward to be fingerprinted. After that, you'll meet with the probation officer. Who's next, Mr. Manning?
Judge, I believe that concludes my business. May be excused.
Yes, and I assume Mr. Windsor never appeared.
Judge, I have not been able to track him down at this point.
All right, the court will have the name Demetrius Windsor called loudly and distinctly 3 times in the courthouse. Failure to appear will result in issuance of a judgment nisi alias Counsel. Mr. Offord,
Judge, I believe that concludes my business. May be excused.
see you this afternoon.
Thank you, Judge.
All right, the court finding that Demetrius Windsor, having received notice of today's hearing for arraignment, has failed to appear as ordered. Name has been called loudly, distinctly 3 times in the courthouse with no response. Court hereby issues a judgment nisi and alias capias and sets new bail in the amount of $100,000. This is cause number CR 25-101, State of Texas versus Vincent Offord. Mr. Offord, we're set for arraignment today and also on status of hiring an attorney. Have you hired an attorney?
Yes, sir, I did. With him, misunderstanding, I give the person the money to, to pay the attorney for the payment, down payment. And she didn't, her card got declined, the credit card. That's what the problem was. As soon as I can get here, I can get to him, I have it all taken care of.
So you have the money or you don't have the money?
No, I have the money. I had gave the lady the money to, pay my attorney, for the credit card. Cause I had, set up a payment plan, pay for the lawyer. That's what it was. But I can get back to it. I can get it to him, I have an attorney though.
So how much money did you give?
$2,500.
You gave a lady $2,500
Yes,
for her
yes.
to use her. Why didn't you just give the $2,500 directly to the attorney?
Well, because I'm working, so much though. I'll get it handled though. No problem. I go get it taken care of.
So this lady is going to give you your $2,500?
Yeah, that's no problem. I have an attorney, but if I come back, you give me enough time to come back, I'll be back. I'll take care of it. I will
All
be.
right, Mr. Offord, this is what we're going to do, okay? I'm going to reset you for August 12th.
That's next month.
That's next month.
Yes, sir.
But I'm going to order you to have the attorney paid within 10 days.
Yes, sir. I have the money. No problem.
So I expect to see a letter of representation from an attorney within 10
Yes,
days.
No problem.
Okay, so
Yes,
that doesn't mean pay them the day before court.
No.
I mean, within 10 days, I want the attorney paid, whoever it is. I just want a letter of rep saying that they represent you.
Yeah, I have them. Yes, sir.
And then have them back here in court with you on August 12th.
Yes, sir.
All right, I'm gonna have you sign a notice of appearance.
Right.
and you'll be free to go.
Thanks, sir. They'll contact y'all. So. Thank you. Thank you.
Is there anyone else on the docket that we've not called? So Mr. Windsor was the only one that did not appear today, is that correct? All right, I believe that concludes the the court's morning criminal docket. Court will stand in recess until 1:30.